I republished the American Slave Code in exact accordance to this 1853 publication, without adding or omitting a word. So when you purchase the book, it keeps it around for another 100 years simply because everybody that has a book, somebody is going to come across it 100 years from now and they'll have it, just as I did. Inheritance of Slave Property, Chapter 4. Slaves as property are transmitted by inheritance or by will to heirs at law or to legatees in the distribution of estates. They are distributed like other property. This feature of the slave system, like all its other features, is derived from its cardinal principle of property in the bodies and souls of men. Without this principle, the whole edifice falls to the ground. With it, the entire system, in all its parts and entire, is sustained. We have already stated the law on this subject. The slave may be sold at the suit of creditors or legatees. Stroud, page 51. A more specific recognition of this feature is found in a law of North Carolina, substantially copied by other states, in which, after prohibiting, in a great measure, the further introduction of slaves into their limits, a proviso is added that nothing in this act shall prohibit any citizen of this state who may obtain slaves, etc., by marriage, gift, legacy, device, or descent, from bringing the slaves, etc., into this state by land or water. Hayward's Manual, 533 and 534. Act of 1794, Chapter 2, etc., etc., etc. Bide Stroud, page 55. Footnote. It has already been seen that these prohibitions have not prevented an immense slave traffic between the states. In some of the states, these prohibitions have been repealed. This indicates what is the known fact, that slaves had previously been inherited in the several states. The inheritance of slave property appears to have occasioned much litigation in the courts, and accordingly the topic occupies no little space in the reported decisions collected together in Wooler's Law of Slavery. In the case of Beatley versus Judy, etc., in Kentucky, it was determined that the phrase personal estate in wills and contracts should be construed as embracing slaves. 2 Washington Report, 1 through 8. The same in the case of Plumpton versus Cook. 2 Marshall's Kentucky, Report 450. Copied by Wheeler, page 2. Footnote. In our quotations from Wheeler, we often, to save room, omit his statements of the names of the litigants, the judges, and the reports from which he has copied. We preserve these, in some instances, that the reader may be impressed with the matter-of-fact nature of the record, and not fancy himself reading legal fiction. Whatever may be said of statutes, the daily decisions of courts are not obsolete, nor are they theoretical abstractions. In the case of Banks, Admiral versus Marksbury, it was decided that the owner of a female slave may give her to one of his children, and the future increase, that is, unborn children, to another. Wheeler, page 28. The case is reported at length. We give here, as in many other instances, the brief marginal statement of the compiler. In the case of Carroll and others versus Connett in Kentucky, Robinson, C.H.J., it was held that the administrator is liable for failure to distribute slaves. Although for some purposes slaves are declared by statute to be real estate, they are nevertheless intrinsically personal, and therefore are to be considered as included in every statute or contract in relation to chattels which does not, in terms, exclude them. They are liable, as chattels, to the payments of debts. They may be attached as chattels, and they have invariably been treated as chattels in both Virginia and Kentucky, so far as the rights and duties of administrators are concerned. Wheeler's Law of Slavery, pages 37 and 38. And yet, Kentucky is one of the only 2 states in which the statutes have declared slaves to be real estate, a tenure which, if adhered to, would attach the slave to the soil and prevent the separation of families. The practice, as sanctioned by custom and the courts, is in this case found to be less favorable to the slaves than the words of the statute, in their plain import. The people have been worse than their statutes, and the judges have conformed to the people. In-laws versus in-laws. Spring term, 1821. 3 Marshals, Kentucky, Report 228. The court held that the slave of a female, immediately on the marriage, vests in the husband, and although she may survive him, her right to the slaves is not revived. Willard, page 39. A wife's estate is in dower of slaves by a former husband. On her marriage vests in her husband, and her right to manumit them is gone. Willard, page 182. Slaves are subject to dower in all the states. Not only are they subject to dower, but the widow's interest in them is protected by statutory provisions. If the husband manumits his slaves, whereby creditors and the dower are affected, the manumission is so far ineffectual that the manumitted slaves may be sold for a period, and the proceeds applied to the creditors of the former owner and his widow. Willard, page 181. Slaves are divisible, like any other chattel. A distinction, however, exists, where slaves are considered as real property. In these cases, they pass immediately to the legatee, and not to the executor as personal estate. Willard, page 57. If a father, at the time of his daughter's marriage, puts a Negro or other chattel into the possession of his son-in-law, it is, in law, a gift, unless the contrary can be proven. Willard, page 62. The increase, namely, the children, of slaves born during the life of a legatee for life, belong to the ulterior legatee, who is the absolute owner. Willard, page 23. By the Revised Code of Mississippi, page 50, slaves descending from an intestate may be sold by order of the orphan's court, where equal division cannot be made, and persons holding life estate in slaves, or guardians for infants, are required to deliver a list of slaves to the register of the orphan's court, and also the increase, page 51, and similar provisions exist in the other states for the division of slaves. Willard, page 183. On the same page appears, however, the following, which seems less inflexible. It appears from the table of cases that the court was held in Virginia, held by the court that an equal division of slaves in number and value is not always possible, and sometimes improper, when it cannot be exactly done without separating infant children from their mothers, which humanity forbids, and will not be countenanced in a court of equity, so that a compensation for excess must, in such cases, be made and received in money. Willard, page 183. Here, the humanity of the judge appears to have modified the statute. Everyone is familiar with the phrases inherited or entailed slave property. Such an one is said to have been born to a slave inheritance, or born a slaveholder. These phrases occur in almost every plea for the blamelessness of the slaveholder, and for the innocency of the legal relation. The man was born into it, and how can he be blamed for it? This plea is never more confidently urged than by a class of clergymen who are forward to teach that all men are born sinners and shapen in iniquity, but who would, nevertheless, be shocked at the impiety of the reprobate who should urge his birth in sin, his inherited or entailed depravity, in excuse of his obstinate and voluntary transgression. Perhaps it never occurs to them that inherited and entailed slaveholding, like other inherited and entailed transgressions, incur guilt when they are voluntarily adopted and cherished. In the case of any other inherited sin, they would readily make the requisite explanation. This feature of the legal relation, deemed so innocent, so capable of whitewashing with a supererogation of its meritorious innocency the crimes of successive generations and whole nations of slave breeders and slave vendors, with their approving senates and synods, will be found, on a close scrutiny, to embody one of the most foul and damning features of the whole system, the feature of self-perpetuity, of self-transmission to the future, the quality of seducing and cursing posterity, securing the sin and the shame, the wretchedness and the hopelessness of the unborn. It is an innocent relation, forsooth, because it embodies and because, as is claimed, it even necessitates these results. No feature of the slave system is more terrific to the poor slave than this: the hazards of a voluntary sale by his master. He and his loved ones may escape. The dreaded mortgage and creditor and sheriff may pass them by untouched. But there is a mortgage hanging over them that all the gold of California cannot lift. There is a creditor whose debt against the master must be canceled, but seldom without touching some of them. There is a sheriff whose warrant is already out, who may seize at any day, and will soon seize, but probably not without touching them, if alive. The death of the master is the close of their respite. They are liable to be distributed, like other property, among the heirs, whoever and wherever they may be. For goods they are, and as goods they are esteemed, chattels personal, in the hands of their owners and possessors, their executors, administrators and assigns, to all intents, constructions, and purposes whatsoever. This is the very definition of an American slave, and there is no escape from the condition it describes. But by the fanaticism of abolition, this is the legal relation too innocent to be questioned, claiming relationship with Abraham and Moses, the sanction of Jesus and Paul. From the Georgia Journal: to be sold, one Negro girl, about 18 months old, belonging to the estate of William Chambers, deceased, sold for the purpose of distribution. Jethro Dean, Samuel Beal, executors. Here, again, the practice corresponds with the theory, and the people are in harmony with their laws. How the distribution of slave property among heirs and legatees is effected under the Code Noir, or where slaves are held as real estate, as in Louisiana, we are not minutely informed. If the soil and the slaves must remain together, a distribution would seem to require the whole to be sold, and to one purchaser. We doubt whether such a restriction obtains at present in that state. Under the old feudal system, the estate, consisting of soil and serfs, was kept together by the law of primogeniture, entailing it to the eldest son in perpetuity. The repeal of that law has been justly regarded as a step in the march of human progress. But if the peculiar institution of slavery is to remain, humanity might, perhaps, invoke its reenactment, as it might prevent the separation of slave families, or rather, permit their existence.